Good morning, my name's Alex Woods. I'm a solicitor and I'm also a litigator. My specialty is bringing mis-selling claims against lenders for payment protection insurance as well as other financial irregularities. And I'm also, the last 18 months, been processing PPI work within IVAs on behalf of insolvency practitioner clients. Now, I attended the IPA personal insolvency course on the 29th of November last week, and I got a lot of knowledge rained on me, a lot of additional knowledge. I already thought I'd got quite a lot of knowledge out of attending previous personal insolvency courses and speaking to dozens of insolvency practitioners, as well as litigating complex payment protection insurance claims and as well as advising people on the area of set-off. Anyway, the whole thing is developing and also becoming more complicated and confusing. And I walked out of the insolvency conference on Thursday last week into the blue skies outside the Manchester City Etihad Stadium, and I really felt as if I had been an insolvency practitioner, I wouldn't have known how to go forward in terms of running my business and dealing with the problems of payment protection insurance claims and other financial mis-selling claims. And I cast no aspersions on the distinguished panel of experts that spoke during the course of the PPI panel, nor the IPA itself, who've done whose manful work in consulting and researching in the run-up to producing guidance on what you insolvency practitioners should do about PPI. The thing is, what I wanted to do this video bulletin to give you a fresh perspective on the whole issue. And I'm not an insolvency practitioner. I've only been in the sector a little over 18 months or so, but I have spoken to dozens of insolvency practitioners, and I have instructed my own counsel at South Square Chambers on a set-off case against the Royal Bank of Scotland, and I have spoken to Paul French for 50 minutes over the telephone. I have advised Beat Your Debt. I have advised individual clients. I have read books. I have attended conferences. Indeed, I attended the R3 Voice of Business Recovery Personal Insolvency Conference at the Hilton. By the way, this is a very useful book and a very nice little publication and a really excellent appendices of materials, reading materials on this area and the relevant extracts from the R3 terms and conditions, as well as the IVA general protocol terms and conditions, and a delicious, for want of a better word, but no, really excellent little opinion by Paul French that appeared in Jordan's Insolvency Law Online. So well worth approaching R3 to get hold of a copy of that. Now, so I wanted to give you an outsider's perspective on this whole issue, and I'm going to tell you the story of how, speaking personally as someone who wanted to and has been setting up IVA PPI processing units so far with 2 law firms, and also run a consultancy and who litigates set-off claims, and so therefore here's something of a plug. So I have considerable experience, be reassured in the issue, although I have plenty to learn too. My journey sort of first started because I wanted to nail the issue. I wanted to know whether or not my business should be processing open PPI claims, whether I should be focusing on completed IVAs, being instructed by the debtor clients directly, whether I was allowed to pay the IPs and introducer fee. Oh God, no. Indeed, whether or not the IP continued as trustee after the IVA completed, whether bankruptcies were going to be a rich vein of gold that was worth mining, etc., etc. Whether the 2004 R3 terms and conditions, whether it's best to pursue PPI IVA claims under those, or whether it was better to pursue them under the 2008 terms and conditions. And I looked at section 7, I looked at set off, I looked at how the terms and conditions, or the R3 terms and conditions, are comparable to the rules in insolvency, such that the issue of mutual dealings arises, and that indeed set off is automatic and self-executing, no less. I looked at the 2008 terms and conditions, and I got advice from counsel at South Square Chambers, who told me that my client in that particular case, in his claim against the Royal Bank of Scotland, would have been able to have got the cash if he'd been under the IVA protocol, 2008 IVA protocol, but since he was under the R3 standard condition terms and conditions, he was not going to get cash, even though his insolvency practitioner, Cambridge Duffy no less, a very large insolvency practitioner, had expressly told him that Royal Bank of Scotland were not allowed to set off his PPI claim. Unfortunately, the clever lawyers, the counsel, told him that at least technically he wasn't allowed the cash, and even though the IVA had been completed for a number of years, he wasn't going to get his money. So, and indeed I had to advise him to drop the case. So I then looked at another case, quite more recently, a case involving a lady who had around about £20,000 worth of payment protection insurance claims in a completed IVA. These are both completed IVAs, so you may be wondering to what extent they apply to open IVAs, but I think that they do. I'll come on to that point in just a second. And she had brought a claim against the Royal Bank of Scotland, and needless to say, once again, the Brady Bunch of set off as far as the banking community is concerned is the Royal Bank of Scotland, and they had kept an account open and they set off a completed IVA. Now in this instance, the IVA, again a large insolvency practitioner, the insolvency practitioner, sorry, had told her that, and they'd provided her with her IVA proposal, and they'd referenced the terms such that as far as they were concerned, the payment protection insurance claim was an asset of the proposal, and therefore it could, the arrangement, and therefore it could be introduced. So she felt quite strongly it wasn't fair, because it was a large amount of payment protection insurance, in my view so substantial that it had probably been a factor, perhaps a major factor, into going into the IVA in the first place. And also she'd behaved, what's the word, she'd behaved impeccably in terms of carrying out her obligations under the IVA. So she had met all her monthly payments, but she'd also got a lump sum payment. She wanted to settle, to bring the IVA to completion early, and she talked to her insolvency practitioner, who told her, if you find, I can't remember the sum, £5,000, we will be able to complete your IVA, your debts will be extinguished, and that'll be the end of it. By the way, that's a big problem, I think, and it's where I disagree with Paul French and Adam Alatar and other counsel, because unfortunately the way that the thing has evolved, and the way that the insolvency practitioners themselves have come to use the tool, the debt management tool of an IVA, which I think is an exceptionally good debt management tool, and I think probably Greece and Spain and Portugal should all be in IVAs, if only we could find an insolvency practitioner and an IVA supervisor in Brussels who was sort of man enough for the job. She had acted impeccably, but in spite of the fact that her insolvency practitioner had pointed to the letter of her proposal and told her different. And so she completed, and as I say, the culture of an IVA is, I believe, somewhat different from bankruptcy. And here's the thing: Royal Bank of Scotland capitulated. It was a big mystery to me. I hadn't done much work on the case at that point. They suddenly changed their minds. So now, I said earlier on that these are just a couple of anecdotes and they were completed IVAs, but here's the thing. I was running a IVA PPI litigation unit as a law firm in the city last year, and I was dealing with insolvency practitioners, our clients of course, and what I discovered, and I had to go through the sort of teething troubles initially to realise the importance of this to insolvency practitioners, is that they didn't just want the money, they didn't just want the 15%. I mean, it's not all that much money for the potential amount of work that's going to be involved for a small or medium-sized insolvency practitioner, but they wanted someone to take the rap. And I've heard an insolvency practitioner put it quite eloquently. He wants someone to put their balls in the grinder, and that is something that is going to require a certain amount of work. And I think that therefore it's going to be necessary for insolvency practitioners going forward in the future not to worry about the law. I mean, I'm going to just read out to you here some choice remarks which Paul French won't thank me for from his otherwise exemplary article. No, and it is exemplary. I found it incredibly valuable. But look at this. Look at how much uncertainty appears in the subtext of what is written. And I just scanned through. Insofar as the claim is regarded as a cause of action, it is likely that, generally speaking, the same view will be taken. That being the case, it is likely, and it is unlikely that the claim will be. The position may be different, while there is no general definition. Probably covered. Generally. It is not necessarily. Usually, in brackets. And the article here is a rare instance of a barrister actually want to deliver to their client a proper answer, rather than some sort of vague, non-specific opinion. You know, as counsel has tried to say, and he says in here, he comes sort of, if you like, on the side, down on the side of the banks, the creditors, or at least the lenders, and he says here, look, generally speaking, with various caveats, I do recommend you get hold of this publication. I'm going to just draw it to the camera's attention once more. I don't know if you can see that. The R3 personal insolvency booklets from the course that they ran on the 23rd of October 2012. So he comes down on the side of the lenders and really answers the question, the two questions: is PPI an asset of the arrangement, and if so, is the lender entitled to set off? He comes down and the answers yes and yes. So, however, I hope that I will have alluded to, and I've just consult my little aide-memoire here, to the fact that I think there is quite a lot of uncertainty in this area, and I will just allude to just a small handful of illustrations of that. Of course, section 17.6, repayment, mutual dealings. Is there not any element of good faith as far as the equitable law of set-off is concerned? The equitable law of set-off is the fair law of set-off is concerned. Is it really a repayment? What was section 17.6 designed to address? I don't think it was designed to address a PPI scandal, and it's a classic case of the law being an ass. Because a PPI scandal has turned up and made a nonsense of all the usual bankruptcy laws and practices and rules and guidance and such like. So the barristers manfully tried to tell you what the law is as an insolvency practitioner, but there is no easy solution. Another example, of course, is it's an accepted principle of English law that a company made up of a number of companies cannot be, one company is not to be treated for the purposes of set-off as the same entity as a subsidiary company, such as the company that provided the insurance that was then sold by the lender, the insurance intermediary, to the punter. So there are, I think, and Paul French also points to the exception of a payment protection insurance claim that's passed through the hands of the Financial Ombudsman Service, and whether that can be called a cause of action. I've given you illustrations of two cases that went completely different ways, and I think that at the end of the day that there is no answer, but there is a solution, and the solution is not an easy one to swallow, because the solution is work is going to be needed to be done. Either you as an insolvency practitioner are going to have to start to become a little bit of a mini expert in financial mis-selling, which requires some time and effort, or you're going to have to appoint your own in-house unit that's going to become a little bit of an expert in financial mis-selling, or you're going to have to need to use one of the service companies, whether it's the company that I'm consulting to in Norwich, whether it's the firm whose name shall not be mentioned, law firm, whether it's the racing car boys at the insolvency conference on the 29th. That's you cut some deal where you only take 10% of the of the PPI refund introduced into the IVA, and in return they install a racing car toy in your reception area. It's just an idea. So you're going to either have to do it yourself, or you're going to have to use a service company to do it for you. And here's the thing that finally tipped it for me in terms of realising that there was no answer to this issue. Apologies to the IPA, who are working very hard to provide guidance, but my prediction is that the guidance will simply say you've got to use your noodle. The thing that finally tipped it to me was walking into the personal insolvency conference on the 29th of November, meeting an insolvency practitioner I knew, who said to me, "Hey, you know what? I'm now worried that if I do let the creditor set off, that the debtor's going to come after me down the line, or instruct some dodgy solicitor or claims management company to come after me down the line for not giving them the cash, after I'd been telling them for 5 years that once they'd completed their IVA, that was the end of it, and they could move on with their lives. You're professionals trying to do a job." So that's what tipped me. Now the other thing that so you're going to have to work hard to sort out this problem yourselves. I don't think that you simply can not bother and stick your head in the sand. And I confess that I was the chap who asked that question of max recovery during the panel session, because it probably is a question that insolvency practitioners are asking themselves: do I really have to bother? But like it or lump it, I used to be fond of an analogy with BP and the oil slick, and that IPs were like oil cleaning tugs that had to motor around the Atlantic Ocean cleaning up oil spill off of the beaches of Louisiana, because socially payment protection insurance is like a massive oil spill as far as society is concerned, as far as morality is concerned. But I'm now not so fond of that analogy, and I prefer the analogy of a dirty old cellar in which all sorts of rubbish has been dumped, and that you, the insolvency practitioner, have got the broom. So you've got the broom, basically, and you have been, destiny has charged you with the broom, and you are going to have to sweep clean this grungy, grotty cellar full of unsavoury bric-a-brac, But here's the hopeful thing: you never know, you may find some gold coins, but it's got to be done. So to conclude, you know, there's the technical legal position that counsel and solicitors such as myself might take, but I think to, you know, a larger extent, the law has proved and will prove to be something of an ass in dealing with this scandal. There is therefore leaves you with the practical problem of you as a business, as a professional running a business, how best to deal with the payment protection and other financial mis-selling scandals that are around the corner. And you know, although the law is an ass in one respect, in another it's not, because in English law we have the law of equity, and I think the answer to this solution, the answer to this problem, is an equitable one. You've simply got to use your common sense, which was, of all the slides that I saw up during the course of the day in relation to this issue, the one that had a bullet point which said use your common sense was the best one. You've got to use your common sense, and you've got to do the work, and you've got to set up a unit or use a service company to do it, or use a service company to do it for you, and you've got to take a view of each and every individual IVA. That doesn't mean you're going to have to look at all of them. I mean, my experience is, you know, the amount's too small. If the IVA is about to complete, you know, no, it's unnecessary to keep it open for 3 to 6 months. You've just got to take a view. But once you get stuck in, you will become, as I did, become much more efficient and effective at dealing with this issue. I'm just going to quote a tiny section from the Standard Terms and Conditions. This is the IVA Protocol Standard Terms and Conditions, and I think this is the most relevant. Section 10.4, the supervisor's functions. The supervisor will have the power to do such things as are necessary or helpful to implement this proposal. I think that's what you've got to do. And you know, at the end of the day, speaking as a lawyer and a litigator, you know, news just come in. Litigators don't worry too much about what the law says. They know what's a strong case, they know what case has merit, and then they grab whatever law that they need to make their case strong and to ensure victory. Well, thank you very much for listening. That's a bit of rough and ready and full and complete voyage around the issue, but I will fully intend to run these video bulletins perhaps on a weekly basis for the benefit of providing insights to the insolvency sector. You know, and so I've got someone to soapbox to. So do stay tuned in. They'll be run on I anticipate a weekly basis, and also a check in on LinkedIn, where I'm now sort of getting into LinkedIn, finding it quite a valuable tool, and a lot of your fellow professionals do use and do benefit from using LinkedIn. Thank you, and that's all for today.